Hello, I just wanted to check and confirm that this works. Let me know if you can hear me.
I can hear you.
Yes, ma'am, we can hear you.
Good evening, ma. I can
Great.
hear you.
Okay, all right.
All right, good evening, everyone. Can we all hear me?
Good evening,
Hello,
sir.
good evening. Can you hear me? Oh, all right. Thank you, Victoria. Welcome to class, everyone. Thank you so much for joining in. We are especially welcome to our stream of classes for week 6. We're starting off with the business and human rights class, and we'll be commencing in 1 minute. But I just want to especially welcome all of us that have been able to join in on time. I trust that we'll be having an amazing session. We already have two of our mentors that will be taking us into this class already on the call. So I just want to use this medium to say a special thank you to the mentors firstly for making out time to being here with us in this session talking business and human rights. We are really, really happy to have you on board. All right, so to just quickly introduce myself, my name is Dennis Williams. I am the program coordinator for the JIIPCC Mentorship and Internship Program, and for today's class, I will be handling moderation. So, yeah, welcome to class, everyone. So I will just run us through what we'll be doing in the session, just giving us more of an agenda briefing of how class is supposed to go. So, yeah, we'll be starting out by introducing the mentors that we'll be having in class. We have three mentors scheduled for today's session, and we trust that we'll be meeting them very, very, very soon. And then each mentor will have, I think, roughly 20 minutes each for their presentations to give us their discourse into what they have found out or thought out for the session today. And then we'll kind of just take questions, have a small discussion about certain key issues, and then we'll call it a close to the session. So we hope and we expect that everything is going to run well. So let's buckle in and get set to really have an amazing session. So to introduce our mentors in today's class, like I mentioned, we'll be having three mentors. So just to introduce all of them at the same time, our first mentor for today is Mrs. I let me Mrs. Shoro Nadi. Sorry, Ma, if I didn't get the proper pronunciation of your name. Please, Ma, when you are up, you can help me. You can help correct me. Mrs. Roots is a seasoned lawyer, chartered mediator, and administrator with extensive experience in human rights advocacy, policy development, and social impact. She is passionate about designing and implementing capacity building programs, managing partnership, and promoting sustainable development across Africa. She has demonstrated expertise in leading initiatives, advocating for vulnerable populations, and collaborating with members of parliament, governments, NGOs, and private sector partners to deliver impactful solutions on human rights and climate change policy issues. Ruth is a dynamic media contributor, having appeared as a panelist and guest on numerous radio and TV programs addressing critical topics such as human rights, climate change, and social justice. As a resource person for the Anambra State's Working Group meeting on CLEEN Foundation and participated in Child Justice Administration training organized by the Rule of Law and Anti-Corruption, a project of the British Council. As a prolific writer, Ruth has contributed thought-provoking articles on torture, prisoners' rights, juvenile rehabilitation, and climate justice, published in prestigious national and international platforms, including Premium Times. Woods holds a master's degree in international human rights law from Nnamdi Azikiwe University, graduating summa cum laude. Currently, she serves as the regional coordinator at Climate Parliament, where she works on advocating climate financing and green energy initiatives across Africa. She also holds leadership roles as the National Secretary and Legal Advisor for the Mandela Washington Fellowship Alumni Association of Nigeria and as a lead partner at Lux House Attorney and Solicitors. In addition, Ruth is a 2024 Mandela Washington Fellow in the US under the Public Management track at Yale Cohort 2 Fellow, specializing in policy making and public management and a facilitator at E-Team Leadership College. Ruth leverages her extensive experience to provide enhanced policy advisory, strategic planning, and administrative service to government, regional, and international entities committed to driving social impact and sustainable development. Thank you so much, Mrs. Ruth, for joining us. We are happy to have you in today's session with us. We look forward to hearing from you. Share your thoughts with us in the session. But just to go ahead and introduce our other mentors. Secondly, we have Mr. Paulinus Chukwuebuka Ikeora. So Mr. Paulinus is a legal practitioner with years of experience spanning through areas such as criminal litigation, civil litigation, capital markets, regulation compliance. He currently works with Ikeora Legal LPA, full service global law firm with offices in Abuja, Accra, and Lagos. Ebuka is the secretary and legal advisor of Foundation for Religious Freedom. He is also the African Regional Director of the Atheist Alliance International, an organization working for a secular world where public policy, scientific inquiries, and education are not just determined by myths and religious beliefs, but based on sound reasoning, rationality, and evidence, and where individuals who like religious belief enjoys liberties, free speech, freedom from association, and freedom to participate openly in public life. He partners with Unchained Vibes and the American Bar Association Center for Human Rights to protect human rights in Nigeria. Ebuka is remarkably adaptive to new models, technologies, and careers. He has interests in areas like software development and violin. For hobbies, he enjoys articling, soccer, badminton, and driving. You can reach him on, that is his email there, right? Ebuka.ikeora@nigerianbar.ng. Thank you so much, sir, for joining. I'm not sure if he's here on the call yet, but we are hopeful that when he joins us, he will get to join us in the discussion for today. And last but not least,
I'm on the call.
Oh, all right, sir. Thank you so much. So last but not least, we also have Mr. Joseph Obo. Mr. Joseph Obo is a multidisciplinary policy and governance expert with over a decade of experience spanning business and human rights, international diplomacy, technology law, and capacity building. With approximately 12 years of experience at the National Human Rights Commission, he has developed a strong track record in advising public and private sector institutions on regulatory compliance, corporate accountability, and the implementation of global standards, including the United Nations Guiding Principle on Business and Human Rights, and that is under the UNGPs. His expertise expands to international cooperation, stakeholder engagement, and policy development, supported by experience in multilateral environment and cross-cultural diplomacy. Joseph is the founder of Navigate Africa and Nigerian company, through which he has provided regulatory compliance service to over 2,000 diaspora and local corporate entities operating in Nigeria. He is also the co-founder of the JIIPCC Mentorship and Internship Program and currently serves as the president of the South Korea International Cooperation Association of Nigeria. Through these roles, he leads initiatives that deliver training, policy advisory, and consultancy services across Nigeria, advancing sustainable development and responsible business practices. A DAAD and COICA fellow, right? Joseph holds a master's degree in information technology and telecommunication law from the University of Strathclyde, Glasgow, United Kingdom, and a master's degree in international affairs and diplomacy from Ahmadu Bello University, Zaria, Nigeria. He combines a global perspective with practical implementation, positioning himself as a trusted expert in governance, regulatory compliance, and development-focused systems. Thank you so much to all our mentors for joining. I wanted us to fully go through all their profiles so that we can get to properly meet all of them, get to know their areas of expertise and their passion within the area of business and human rights. And like I earlier mentioned, in the next 20 minutes, roughly for each of our mentors, we'll get to hear them share their thoughts and perspective on the subject matter for today. So the way we'll be going is that we'll be moving from one mentor to another. And I would like for us to start out with Mr. Joseph, and then we'll move subsequently to our other mentors. So, Mr. Joseph, if you're with us, sir, thank you so much, sir, for joining. Like I read in his profile, Mr. Joseph also happens to be the co-founder of the JIIPCC mentorship. Thank you so much, sir, for this initiative that you, alongside the founder, put together to ensure that we get the training that we need in the various aspects of the courses that our mentees have chosen to embark on. So, Mr. Joseph, over to you, sir.
Thank you very much, Mr. Dennis. I just want to say a very big thank you to the co-mentors that are here today. I acknowledge you, my learned brother, Mr. JIIPCC, and my other learned brother, Mrs. Ruth. Some people might be wondering why I didn't say learned sister. You know, I think we're all brothers, you know, one way or the other. So it's really a pleasure to meet all of us on this platform, and also the mentees. It's really nice to be here. I hope that what I have to share here would be useful for everyone here. But just as a background, my background basically is I love human rights, right? I love I can easily tune into a human rights mode, as in that has been my default setting, you know, since I can remember. Things that have to do with protecting people who cannot protect themselves is what really inspires me a great deal. But I would also say that I've had the privilege of supporting companies at the boardroom level. And I know that almost everybody here, one way or the other, would have some level of interference with a company one time or the other in your life. You might work for one, you might own one, you might consult for one. Like, you would definitely have that interaction. And having spent about 12 years working for federal government in the National Human Rights Commission, I had a great tenure. Spent 12 years, became a chief legal officer. Then I decided that my time was up. I need to face the outside world without government backing and support, and, you know, the whole salary mentality. That was just my view. I'm not saying that those who are there have a salary, but I just felt I needed to really do more. I needed more exposure, and I just wanted to be on that whole, having my time to myself and pushing towards life in that direction. So, of course, JIIPCC, we've come a long way with JIIPCC, almost about 5-6 years now. And I really want to appreciate all our mentors who give themselves to this platform. We cannot reward you. That's the reality. You know, much of the things that mentors actually give here there are things that people pay thousands of dollars for in other climes. So we don't take that for granted. Yeah. So I would just quickly delve into my presentation. I don't know, Mr. Dennis, if you don't mind, if you can kindly help me to walk the slides, I would really appreciate that. Thank you so much.
All right, sir. I will need a minute to do that. Just give me a minute, sir.
Okay, so I can just proceed then. I will just keep sharing until the slides are up. So basically, I want to look at some case studies today on business and human rights. I want to look at some case studies. I want to look at case studies primarily from foreign countries, basically. And the goal basically is to see how we can transmit those principles, the principles within the UNGP, that's the United Nations document by John Ruggie, yes. And that document primarily outlines 3 pillars. But so that I don't move beyond myself, my hope basically today is that we are going to be able to understand how real companies deal with human rights crisis. That's number 1. Then 2, we're also going to look at what could go wrong. What goes wrong in companies when companies adopt, a human rights approach to business? What are the things that can go wrong? Then we're also going to see how law, power, business decisions interact globally. That's going to be very clear. That's going to be very clear. Then at the end of the day, I'm hoping that as future leaders, everyone here is a leader in his or her own right. So my expectation is that we would think about the principles and we would go with the gospel of business and human rights at the end of the day. So the point where wherever we find ourselves in the corporate world, in the either corporate or in any sector, basically you find in because business and human rights, the ideas or the ideas around it are philosophical in a sense, but they have practical impact. When those philosophical ideas are not given practical relevance, it could really cause distortions in society. I remember one particular case about 2 years ago. This case happened in somewhere in Nasarawa State, a mining company that was run by not necessarily a multinational, but in that sense, foreigners ran the mining site. And of course, for women who intended to work on that site, you guys can already tell how much these guys are paid. They still had to sexually violate some of those women to give them access to even work in those particular mining sites. There was another story as well. I'm just trying to give you a background so that you can begin to look at the implications of human rights when businesses, corporate bodies are actually involved. There was this, was it like an eatery in one of these airports? One of the airports, I think the airport in Lagos, and the eatery was there. Somebody comes in on a wheelchair, tries to access, food. He wants to buy food to eat. You can actually go it. And at the end of the day, the staff that work in that particular eatery, they're like, his wheelchair is occupying space in that premises. So therefore, please move out so that people who can stand on 2 legs can buy food to eat. So it can already tell you that is the corporate mindset of the individuals working within that premises. It already shows you the absence of their understanding of the fact that even though that premises is owned by a corporate, the activities that go on within that premises are already subject to human rights rules, norms, laws, procedures, processes, and all of that. So the point is just to give you an idea before we just quickly delve into what business and human rights is. I will just quickly lay a very brief foundation, then we just dive right into the case studies. We have a few discussions at the end of the day, and we can learn from one another. So the first thing I would say basically is I already talked about the United States guiding principles. Those principles were promulgated or were supported, or better yet, should I say, were propounded under the leadership of John Ruggie. And the human rights, the UNGP has 3 main principles. 3 main principles under the UNGPs. We call it the 3 pillars. The first one is the state's duty to protect. So I'll ask yourself a question. You are a Nigerian. Okay, better yet, I believe that many of us here might be Nigerians. We may have maybe 1 or 2 or 3 foreigners here. But think about the duty of the state to protect. Just think about it. You have the courts, you have government agencies, you have policies around access to justice, all of those things. Those things fall under what can the state do to ensure that human rights are enjoyed by anybody who is a human being, whether you are a foreigner or whether you are in Nigeria. As far as you are within, the jurisdiction of Nigeria, you should be able to enjoy a certain level of protection from the state. That's number one, the first pillar. The second pillar has to do with corporate responsibility. That's the duty of companies to respect these laws, to respect these principles in carrying out their services. So take any business, for example. You can even look at maybe the agri sector, where you find out that there is a lot of child labor in many countries across the world. It's not just a Nigerian thing. You can look to maybe you are looking at the maritime sector. You want to look at the conditions under which people carry out their daily jobs within that maritime space. Then you can even look at the oil and gas space, for example. We've had cases of oil spillage, although we've not been hearing so much about that recently. But there used to be a time in this country where almost every month you must hear of an oil spill somewhere, degrading the environment and the impact on the livelihoods of the people that depend on the soil or on the water for their survival. A lot of human rights issues emanate from the activities of companies. So another thing that companies can also look at, of course, would relate to conducting due diligence, and we would look at that in a bit while we look at the case studies. Then the last pillar of the UNGP is the remedies. If there is a wrong, if a wrong is committed, there ought to be a process through which people can assess remedies. So what are we saying now? The victims must have access to effective remedy. They must be able to access the legal system, and they must also be able to claim fair compensation. If somebody's rights has been breached, maybe you're working in a company, and maybe I used to hear of a story in Lagos. I think some persons who were working in an Asian controlled company. I don't want to mention the name of the country. And they would go to work, their bosses would beat them, will malhandle them, would treat them like subhumans. Sometimes they will lock them in the premises of the business for weeks on end. They are working. Imagine slaving in your own country. So when this kind of issue comes to light, what can these individuals do? What is the remedy for them? That is what the UNGP is really trying to talk about. So we're going to be looking at 3 case studies. These 3 case studies, this Barrick Gold case I think it's just a case that came up sometime this week, about 1 to 2, not up to 72 hours ago. It's a Canadian case. We are going to look at that particular case and now see how that, when we talk about human rights, sometimes we feel that people might have it worse in this part of the world, even though sometimes the thinking around human rights and business, persons or courts might want to make decisions on the basis of the interest of their country or the interest of the businesses that emanate from a certain jurisdiction, not necessarily basing that particular decision on the human rights implications of the victims. So this Barrick Gold case, I put here justice denied or justice delayed. That choice is yours. But I want to emphasize that this is more of this is like an Ontario Court of Appeal decision. This decision by the Court of Appeal in Ontario, it's definitely going to go to the Supreme Court. So this is not the final decision of the court in this particular case. But I'll just run down on a few things that happened in this particular matter. It took place in Tanzania, a country in Africa, in a mining society, and the company that operates the mine is a subsidiary of Barrick Gold Corporation. Barrick Gold Corporation has its headquarters in Ontario, in Canada. So they do business in Tanzania. So as a result of Barrick Gold carrying out business, in Tanzania, they have worked with the Tanzanian security forces to maim their own citizens. I'm sure you can almost, if you really dig deep into some West African countries, you can see the pattern. I don't know if it's an African pattern, but it appears that when life is involved, a lot of governments necessarily don't take they don't look to the constitution to really derive that joy to say, okay, we are protecting life, even beyond property. Let's even protect life first. I don't want to get into that mode, but I'm just saying that it's really important for us to see how that some of these things can be very systemic, on the African continent. And I would go on to say that in that particular company, people are beating, in fact, the civil society in Tanzania, they had documented almost 100 deaths as a result of the activities of this mining company of Canadian origin. So that should sink in. That should sink into anybody. Like when you look at how companies operate, maybe you look at certain companies that provide maybe haulage services in Nigeria. Sometimes they run into properties. Maybe their truck explodes or something. Lives are lost. All of those actions have human rights implications. So that's the major point I want us to take from here. But I would just quickly say that the court ruled that the case, because the persons whose rights were infringed upon, they went to Canadian courts. Their thinking was, if they move on this in Tanzania, they might not be able to get justice, because in a lot of countries in Africa, sadly enough, justice in a lot of cases all tilts towards the highest bidder. And I'm not trying to disparage the justice system, across some countries in Africa. But the point I'm trying to make basically is that when people do not trust that when they go to the courts, that they are going to get justice, there's already a fundamental problem within that particular system. So you now find that these guys, they now went to Canada to see how they can get justice, and the Canadian court says no. Even though the company has their headquarters in Ontario in Canada, go back to your Tanzanian courts. Go and start all over. Go and get justice in your country. Is there a problem in your country? What is chasing you from your country? Why don't you think you can get justice in your country? And it's still the same reason why a lot of people are looking out for, different other pathways, immigration pathways. People are checking out of continents, checking out of countries because of issues surrounding getting justice. Some will say justice delayed is justice denied. I can't remember but was it Lord Denning? Those are some of the things, 100 level legal system, and all of that. So that's for the Barry Gold case. And you can see that some of the core issues raised here basically have to do with access to justice related issues, technicalities, how that the court can meander its way, to dance to, it's so easy for justice to be two-sided. Sometimes you would just realize that you are thinking that, okay, court is going to deliver this judgment in this way. It goes the exact opposite route, and it can give you the reasons why that particular decision is the correct decision. So we are looking at a global company in this particular context against locals. So what does business and human rights basically try to achieve? It tries to see that, like when we're talking about the corporate sustainability due diligence directive in the European Union, for example, the EU is trying to see that European companies that do business in Africa, the rights of the people that work in their subsidiaries, the rights of the people that work within the supply chain of these companies, those rights are protected. So they came up with a lot of due diligence directions, how companies must ensure that they are able to carry out due diligence within the supply chain of companies that represent European companies doing business in Africa. So that is already telling that there is a lot of shifts, going on. I'll quickly move to the Dyson case. In this particular first case, the Barry Gold case, don't forget that what basically happened in this case has to do with the fact that the issues took place in Tanzania. The case was brought before a Canadian court. The Canadian court says, no, I will not entertain this matter. You have a country, go to your country and for justice. Although that is a court of appeal decision, we are still awaiting the Supreme Court decision in Canada on that particular issue. So I'm just going to quickly go down to the Dyson case. I know most of us would have used the Dyson product somehow. If you use all these electronic products like iron, all these, is it woofers they call them, or hoovers, for cleaning, for maybe cleaning your rug and things like that, you would realize that you've come in contact with a product from that particular company. So in this particular case, the company has like a factory in Malaysia. That's a UK company with a factory in Malaysia. So a lot of allegations, surfaced around forced labor, exploitation of workers, poor working conditions. These issues were actually canvassed and they were brought before a court in the United Kingdom. So when this particular company realized that, oh, if we subject our company to a court, that means the entire company is going to be, in fact, everything around that company will be in public domain. People would now know, okay, is this company even tax compliant? Okay, what are other perennial issues that this company may have been hiding? But once you get to court, your books are open. So for them not to subject themselves through that rigor, basically what they did next, which is quite interesting, was to see how that they could negotiate with the alleged victims. So they actually entered into a negotiation. Primarily they settled that matter before trial even began in the first place. So of course, there was no admission of liability. Somehow the company was still able to keep its reputation to an extent. Okay, there is no court case that has convicted us of any wrongdoing, even though the facts are there that certain wrongs were committed against certain persons that worked in this particular company. But they were able to see how that they did not subject their company to, the process of, the grilling and horrendous process court system, basically. And we can all be very sure of. Some people who have evaded justice in Nigeria, they go to the UK, they get justice. So we can definitely say that this company is already aware that in this UK jurisdiction, there's justice. There's justice in the United Kingdom. So they did not want to go through all of that process. They had to settle, with the individuals, avoiding litigation, managing their own costs. Then also, it just gives you that impression of what now happens to, because it may not be everybody under that whole humiliating atmosphere that got their rights represented before the court in the United Kingdom, even though that court never really had any trial on that particular matter. So when you're talking about the negotiations, how did they negotiate? Was everybody carried along? So all of those issues are still left unanswered. But that just gives you an idea as to how companies try to evade scrutiny in that particular sense. So I know my time is almost up. I would quickly go to the third case. The top case is Vers Rocha. It's also a company. It's a French company that has operations in Turkey. So this is more of like issues around the right of workers' rights, basically. Workers want to join a trade union in a particular subsidiary of a company. And at the end of it, because they go ahead, the company fires almost a third of their workforce, 132 people. They are fired from their jobs. They lose their means of livelihood as a result of the activities of this particular company. So what these guys do, they take that case to Paris, a Paris court, a court in France, and they are able to canvass their issues within that within the courts. And at the end of the day, that matter actually went through the judicial process, and the court now said that the company was actually supposed to have prevented the harm. The company should have prevented the harm that this particular employees, faced in the hands of a subsidiary in Turkey. So we're looking at the company is a French company. The infraction takes place in another country. But as a result of the linkage between the French company and the subsidiary in Turkey, the law still holds that French company accountable. So we can see that in one case, a court is saying, go back to your country. In another case, the case is before a court, but they settle out of court. But in the third case, we can see that the court now looks at the entire issues and they're able to give justice to those persons whose rights were, infringed upon. But the beautiful thing I want us to understand from here is that we are looking at companies, we are looking at the actions of companies. And don't forget that we mentioned that the UNGP has 3 pillars. There's a pillar that concerns the actions, the duty of companies to respect. So that's very key. That's very important. You might find yourself in future working for a company, providing one service or the other for a company, and your ability to have listened to this particular lecture today would give you the added advantage to be able to advise companies to act right, to do right, and to ensure that companies also play their role in ensuring that the rights of the individuals that work within those companies or within their subsidiaries or within in their entire supply chain. In fact, the supply chain might just basically mean that the company may not even be related to the core company. It may be like a company a contracting company or a supplier of a product to that particular company. The rule basically means that those companies that do business with this core company, they also have to comply with human rights rules, ideas, tenant laws, as you have it. So that's also very key, also very important. I'm almost rounding up. I just want us to quickly look at, I think we've talked about what I have here. Okay, I think what you have on the slide, okay, the three companies, yeah, that's where we are. So we looked at the Barry Gold case. We looked at, the victims are blocked from accessing justice in Canada, a whole Canada. With all due respect, anyways, Canada is a great country, but I believe that we are still awaiting, the final judgment from the Supreme Court in Ontario. So that would give us, a very balanced idea for us to see whether Canada is actually moving away from where the world is getting to in terms of business and human rights tenets. So I believe that the justice system in Canada would do right, and we would have a judgment that really looks into, the rights of the victims, basically. So we looked at the Dyson case. The case was settled out of court. Then at the same time, the last case that we are looking at, where the company was held liable, we've also looked at that, and we're trying to see how that, in terms of the pattern shift. So the world is basically changing. There are a lot of changes happening in the world. If you look at the European Union, for example, so much is happening within the EU that gives us a lot of confidence that if the world can model what the EU basically is doing, a lot of things would begin to happen for good. If Africa can even take 15%, if we can adopt 15% and we can have a government system within our continent that really looks at the rights of individuals, I think that would really be like a breath of fresh air, to a very large extent. So what we are saying right now basically also is that location is no longer a barrier. The fact that maybe you are a maritime company, you are doing business in Nigeria, it does not mean that you can act anyhow within our jurisdiction. Even if at all you do, and people cannot get justice in Nigerian courts, they can go to foreign courts, especially courts in Europe. You don't want to try European Union. In terms of policy, they have a lot working for them in that particular regard. Then the other thing I would just add before we wrap up, I think we're going to the last slide. Yes, let me see. I think, yes, we're going to the last slide. Yeah. So I just want us to have these questions in mind. We don't have time to discuss anything, So the first question I have here is, which company handled its situation best and why? Then two, if you were the CEO, would you, one, fight the case? Would you, two, settle? Or would you act earlier? What would be your best strategy, looking at these whole scenarios that we've painted in the case study? Then the third one is, where should justice be served? Is it in the home country or is it in the host country? If I were speaking as a Nigerian, with all due respect, I don't know if I should speak as a Nigerian, but let me just focus on this lecture. A lot of persons would prefer going to a jurisdiction where they are sure they have some level of certainty that they can get justice. Do people still get justice across Africa? The answer is yes. Is justice as fast as we want it to be? The answer could be yes and no. But it's very, very important that we take corporate accountability very seriously. Wherever you find yourself, you're a lawyer here, you're a professional, you work in a company in the future, or you provide support services to boardrooms of companies, you should be able to see how you can begin to propagate this gospel. It's actually a gospel, the gospel of business and human rights. Let people now begin to see, let corporate bodies, let companies, at the C-suite level, at the top levels, let them begin to understand now that corporate accountability is a global reality. One, courts are also increasingly willing to challenge corporations and expand responsibility, then the biggest risks around ignoring warnings and all of that through subsidiaries, that should be like, it should not be a foregone issue. Companies should take that into account. And finally, I want to say a very big thank you to everyone for listening to this lecture. I hope you were able to pick something out of it. But finally, also, the real question is not whether the company would face risk, but whether you would see it early enough, because every company is going to face one risk or the other. If there were no risks involved, we will not have all this due diligence and all of these things. But because that's how quickly can a company respond to human rights related infractions? Yeah, so that's it for me. I've taken a lot of our time. Thank you very much, Mr. Dennis, for indulging me, and I hope that this presentation was quite useful. Maybe, hopefully, we might take questions as time goes on. Thank you very much.
All right. Thank you so much, Mr. Joseph, for helping us run through your discussion into the topic for today, highlighting those cases that you did, asking key questions, and getting to engage our minds to begin to see human rights within a different perspective. Thank you so much, sir. We really, really do appreciate. So we still have two of our mentors on the call. I think we'll be going with Mrs. Ruth next. Please, ma, if you're with us. Also, in roughly the next 20 minutes, we would like to hear your discourse, and then we'll give the floor to Mr. Ibuka last.
Okay. Good evening, everyone. Thank you very much for this opportunity to take this session today. And I must appreciate the previous speaker, my colleague, my learned brother, Mr. Joseph. That was a very interesting presentation, and particularly that Barrick's case. It still boils down to, I have my thoughts on that case, but I would reserve my thoughts, but I would just say this: it's as Africa, we need to get our justice system right. While we have recourse to international justice, I really look forward to the time that we get our justice system right. I am actually currently in Toronto in Canada, and I'm doing a research on this that's international law and human rights. So when I say I found that case interesting, it really is. The Ontario Court of Appeal has given a judgment on it. They affirmed the decision of the ruling of the Superior Court. So let's see, fingers crossed, on what the Supreme Court would say. When I say that, as Nigeria and Africa, we need to get our justice system right. I know why I'm saying that. So I will just continue from where the previous speaker stopped on human rights. I have practiced as a human rights lawyer for a while, and also extending my tentacles to international issues with respect to this. But the angle I'll come with in this presentation today is going to be more on what the laws say in Nigeria, just to let us know, because sometimes with respect to businesses, we are sometimes the law could be there, but it's something that we are not so aware of. So I just want to either bring this to our remembrance or let us know about it. So my focus is going to be on labor rights and artificial intelligence. And I would not waste so much time, because there's a part of this, my presentation, that I want to get to. But on this aspect of labor law and human rights, why business and human rights matters is where I'll start with. It is very important. The first speaker has already talked about employment conditions are so important. Companies have an obligation to ensure that the environment and the working conditions are good for their workers. There is need to protect workers' dignity. There is need for data and privacy. It is really important in this world where information circulates very easily. And this subject matter is also important because it helps with access to opportunities. So, Mr. Majeto, you can share the slide if you want to, but sometimes the slide could be distracting. But I mean, if it's the norm, you could. So, another reason why this subject matter is important is it helps to reduce economic inequality. And the first speaker has also mentioned a bit of, the international standard on this. UN has some guiding principles with respect to labor law and human rights and business, and it places a responsibility on the state to regulate businesses that happen within it. And this is why I say that Africa needs to get our human rights policies and our justice system up and running. Is that my slide?
Yes, it is, if I'm not mistaken. Yes.
Oh, please. Oh, please. Oh, please. I actually sent a wrong one. I'm so sorry about that. That was the first slide I prepared and I did not. Oh, please just stop sharing. It's not. Let me just resend the right one to her. Sorry, just give me a second. Okay, I would, that's not the right slide. Yes, if you look at it, you just see that it's not complete. That's not the slide the last slide I worked on for this. Okay, I would send that soon, but let me just continue. I would send this immediately after this class. Okay, is that okay?
Yes, that's fine, Barros. Thank you, ma'am.
All right, you're welcome. So we have the UN guiding principles or the global standard. There is a responsibility for the states to regulate business and the conduct of business within its territory, even for international companies. But where we have the state silent on it, gives some companies the idea, especially international companies, that they can come in and, do anything and get away with it. And unfortunately, sometimes they do. It's quite sad. All right. So now, after the state's regulation, this is the order. The state regulates. Now, the business has there's an expectation on the business to prevent harm to as much as possible to its staff. And then the victims, there is a responsibility on them to be able to access justice. That's the order. States regulating, businesses have the obligation to prevent harm, and then victims, where these two entities did not do their work, have the privilege to access justice. Now, there are certain fundamental worker rights or business rights for those that work, which is one, fair wages, safe work places. I won't go into this so much because the first speaker has already talked about this. Non-discrimination, freedom of association, reasonable working hours. This is something that in Nigeria, it is difficult. I see people that wear this as a badge of honor. Their boss calling them by 10 p.m. in the night and blah, 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 especially in the so-called big, whether law firms or finance audit companies. It's not a thing of pride. It's not. Yes, there are times where there is a project that would need a certain level of overtime just to complete that, but it should be a one-off. It should not be the regular thing. And then lastly, in businesses, your staff or your employees have the right to social security. Now, Nigeria has, a legal framework for business and human rights. It's not like we don't have these laws. We have the Nigerian Constitution that's, talked about protection of dignity. We have the Labor Act that has some really good provisions for that. Under the Labor Act, I think Section 15, where a company is supposed to have a regular and specific time for payment, and where it doesn't comply with that obligation, there is actually a penalty. But you and I know that there are some companies, there are some organizations that owe their staff for as much as 3 months, 6 months, and they're still running. That's something that's in saner climes, it would not fly. You have to file for bankruptcy, shut down. You cannot be having people work for you as a charity when you're not a charity organization. Okay, then we have other legal framework. We have the Company and Allied Matters Act. We have, the Trade Unions Act, Employee Compensation. And these are quite old laws, but they're still sort of regulating workers' rights in Nigeria. And then we have the Minimum Wage Act. Then technology and business, which is something I want to focus on. So there is still this law in Nigeria that I want to just highlight. It's not so common, but it's there. And this is a very important law for businesses, and it's the Federal Competition and Consumer Protection Act. Now, I want to say this because some of us, if you're not running a business now or you don't have an organization, you may have in the future. And in fact, these days, a lot of people run businesses by the side and get to do 1 or 2 things by the side. Now, there are some provisions of this Federal Competition and Consumer Protection Act that is just flouted by a lot of small businesses, very commonly in Nigeria and Africa, that I just want to highlight. But this law is a Nigerian law. I wasn't so sure of the audience, but I believe that a majority of us are Nigerians. So now the Act provides for right to goods and product of goods to be of good quality. It should be free from defect and in correct working order as described before purchase. It's not a case of what I ordered versus what I get, and then they'll say no refund after payment. That's so wrong. That is an infringement of human rights of your of whoever is buying that from you. And there has to be that implied right that the services are performed properly and in the quality that a reasonable person will be entitled to expect. And also that law provides for an implied warranty on all consumer transactions, that the goods and services that you're offering comply with industry standards. And then the right to return all goods of poor quality that do not comply with the provisions of the FCCPA within a stipulated period after payment. All this now, and the Act provides that this should be for a period of 3 months after receipt and complaints about quality. So I see a lot of Instagram vendors that would say or not even Instagram vendors, generally they'll say when you buy a good, you don't return it, except that was, clearly stated. I mean, there was a legal contract of some sort. And this is still on the basis of the fact that the goods that you're offering, that you offered the client, is the same as what was advertised. Okay? And the act even mandates that all businesses should repair or replace defective and returned goods, or refund the customer or the consumer a portion of their purchase price. And this is equally applicable. The act also makes provisions for customer services, that the customer has the right to receive information about the goods in plain and understandable language. And then the customer also has a right to full disclosure of the prices of goods and services during the transaction, and to price changes before payment. I'm just highlighting some really important parts, because we would see people that would advertise goods, no price. It is actually against the FCCPA Act. And then right to proper labeling of goods and an honest description of the goods or services. And then the customer has the right to examine the goods before payment, or if he chooses to waive that right. And then, of course, generally the right to fair dealing in all transactions. And that's by fair dealing, the customers also have the right to be treated fairly and honestly when dealing with small businesses. There are lots of very relevant provisions on that FCCPA Act. I'll just leave us with an assignment to go back and read it, especially those of us that are actively involved in business, so that you would not. One thing about this, about our laws in Nigeria, yes, our justice system, the wheels of our justice system seems to grind slowly, and sometimes you're not assured of it. But every other time, there could be someone with an understanding of his or her rights that would stand on business, and you could be made an example of it, whether as the business owner or as the consumer. That's why I'm bringing all this to our notice. And also there is this important provisions also that we have in Nigeria with that's the Sale of Goods Act. It also has some relevant provisions that relate to businesses. And another very important law that I just want to highlight a few portions of respect to human rights and business in Nigeria is the Copyright Bill. The Copyright Bill that was signed into law in March 2023, it's effectively replaced the Copyright Act of 2004. Now, certain workers, these are people that deal with intellectual property. Now, certain workers under this act, certain workers have rights to the work that they create while employed by their employer. So that act divides the copyright into it has two aspects: the moral and economic rights, of which only the economic right can be transferred or assigned from the creator. But if the employment contract says that the employer owns the copyright, you only have the economic rights, but you still need to give credit to the creator. I'm just highlighting this because these are some very pertinent issues with our generation, that it's more digitalized now. So beyond what has existed before, intellectual property is now a thing, and it's a business right. So for creators, know what the law has specified in this. So the Copyright Bill actually gives, the worker a right to the creation of that. If let's say this is you're a graphic designer for a company and all that, the economic rights could belong to the company, but the moral rights, still lies with you, and the company has, the obligation to credit you as the creator. So this copyright only passes when you as the creator transfers it to someone else. That's why you really have to be careful with what you sign as a creator in the corporate world. it's really important. So back to my slide. So the next thing I would want to just highlight is technology and business. Now, we have a lot of automation and digital systems in our corporate world presently, and these things affect hiring decisions, they affect performance monitoring, they affect worker surveillance. We have AI that goes through CVs and all that. So one of the things that technology does is that it improves productivity, but sometimes it could affect workers' protection. This is really important. I wouldn't say, I am not part of that group that would say don't use AI. I mean, we should have all been past that now, but we need to use AI with with our human intelligence. It's called artificial intelligence for a reason. It helps, but everything should not be 100% sourced to it. It helps. It has really helped with, sometimes with due processes, with fair employment, with equality reasonably, but it is not perfect. We've had cases where, the AI has a bias, and these are certain things that infringe on human rights in businesses, especially in this 21st century. So there is a responsibility for businesses to have like a checklist in the use of AI. The first one is it's very important to conduct human rights due diligence, assess worker impact before adopting technology. We have businesses or organizations or firms that do performance evaluation, and it's more like the artificial intelligence tool that helps with it. So there should also be that human intelligence to regulate it, to ensure that biases are removed. So AI systems need to be tested for bias if you must maintain and uphold human rights in your business or your organization. Then ensure fair wages and safety, provide room for grievance mechanisms. This is really important. For law students, you have the two very important principles of fair hearing, which is audi autorem partem, hear the other party, and then nemo judex in causa sua, that's don't be a judge in your own matter. So there is a need for, hearing the other party. There should be a need for, there should be an avenue for grievance communication in business. That's part of upholding human rights. And then I've said it over and over again, maintain human rights oversight. We have a lot of fintechs now, deploying AI credit scoring. They should test, there is need to test for, discrimination risk, explain decisions, allow appeals. It is really important. Then there is one more law that I would want to highlight. We cannot talk about human rights and business, especially in Nigeria in this 21st century without talking about it, which is data privacy. And the Nigerian Data Protection Act of 2023 is like the Bible for this on data protection for now. So it also has an implementing framework, which is the GATE, the General Application and Implementation Directive of 2025. So it has this two, the act and then the directive GATE in combination has fundamentally transformed how personal data is supposed to be handled in the Nigerian workspace. So these regulations have imposed specific obligation on employers, and establish enforceable rights that the employees can hold on to if it is, infringed. Now we have, monitoring systems in offices, something like the use of CCTV, surveillance monitoring systems and all. Whether CCTV, email monitoring, internet activity logs is not prohibited under any Nigerian law, but it must comply with the provisions of the NDPA, that's the Nigerian Data Protection Act, and the directive, that's the GAID. And there are certain things that NDPA has highlighted. The monitoring must be lawful, it must be necessary, it must be proportionate. And then the GAID also reiterates that surveillance in the workplace must meet, there are 3 basic tests that it should pass. It should pass the test of lawfulness, it should be necessary, and it should be proportional. That's, the monitoring should serve a legitimate purpose, and if there are less intrusive alternatives, it should be explored. And then the extent of monitoring should be proportionate to the risk being addressed. So, and even when you're having all this CCTV and other surveillance equipment, there should be notices. Employers are required to clearly inform the employees of any monitoring practices. This must be done through a clear and accessible, well-drafted privacy notice that outlines the nature, the purpose, the legal basis, the scope, the data, the extent of the data retention period and then employees' rights, grievance procedures. These are the things that should be in such documents. And then another thing is the issue of consent. The truth is that it's for in an organization, there is already the balance. There is already a power. How do I explain that? There is already a power imbalance between the employer or the employee and the employee. So, the reliance on consent as a catch-all solution doesn't work with the law. Remember, you have to, apart from, letting them know, that's in ensuring workplace security, data prevention, or protecting company assets, the interests of the employer must still be weighed against the employee's fundamental rights. It should not be excessive and it should not be intrusive. So there is also the data protection impact assessment. So under the GAID 2025, any form of data processing that presents a high risk, such as maybe biometric scanning, GPS tracking, or large-scale monitoring, anyone that presents a high risk to the rights of data subject may require a formal data protection impact assessment. So employers are required to evaluate the risk to employees' privacy and document mitigating measures. So this requirement applies particularly when biometric systems and automated decision-making tools or large-scale surveillance technologies are in use. Then another aspect that I just want to highlight from the NDPA is the data retention and minimalization. So the NDPA specifically requires employees to adhere to the principle of data collecting only data that is necessary for specific and lawful use. That someone is your employee doesn't mean that you should now have, the person has no privacy anymore. You now want to, that's really almost intrude into every aspect of his life in the name, or her life in the name of collecting data. It should not be. Also, private spaces should be reasonably protected. like you're having CCTV, even right in the toilet. There are some things that, should not be, surveillance data, for example, should not be retained indefinitely, except justified by business necessity. So there is a timeline. So another thing that's apart from that's another thing with respect to NDPA in Nigeria, it's that the employees they have their rights they should have the right to access. The employees can make a request for the personal data that their employer holds on them, including monitoring records or internal notes. This is a right. They have a right to access such information that you're taking about them, except is subject to certain legal exemptions. There are legal exemptions, but those are exemptions. And then another employee right that the NDPA provides for is the right to rectification and erasure. So if the data held by the employer is inaccurate or outdated, the employee can request that it be corrected or deleted. He is entitled to that, unless the retention is required by law or necessary for a legitimate business interest. And of course, the employee has the right to notification of data breaches. For example, if this happens, you have an employee database and then there is a breach. The employees should have knowledge of such breach, where it affects their personal data. For example, if a surveillance footage is leaked, the employers should notify the affected individuals and the NDPC within 72 hours, in line with the requirements of the GATE 2025. That's like section 13 and 40 of the Nigerian Data Protection Act. And another thing I want to highlight is, okay, I've mentioned it before, the right to complain and a standard notice to address grievance. So this was provided for in the NDPA and the guidelines GATE. So there are penalties for non-compliance. Non-compliance with data privacy obligations can lead to substantial legal and financial consequences for employers. So don't feel that there's some and I really think another thing that makes employers do a lot of things and get away with it is ignorance too. Apart from, we know the obvious, that our justice system, it's sort of is tainted. While we are hoping for better, the truth also remains that a lot of people don't know their rights, and there is also, because of the country, it's not at its optimal states. It's more like everybody's saying, just hold on to the one you have, don't spoil your chances. So you see people being abused in the corporate space, and they cannot say anything because, one, they don't know, and two, they are afraid. But there are penalties for non-compliance. Once you build your case, once you have evidence, and then once you bring the law, consult a proper lawyer that knows what he's doing. There are penalties. Penalties could include regulatory fines of up to 10 million or 2% gross annual revenue of the company, whichever one is larger. Then we have enforcement orders, including mandatory data deletion, and of course, reputational damage and potential civil liability from affected employees. All right, so I'll end with this. I think my 20 minutes should be up now. So I'll just end with this. Labor rights remain the heart of business and human rights. Artificial intelligence is the new frontier for worker protection. So if you want to have a responsible business, that's one that protects the interest of both the employer, but most especially the employees, because of the obvious power imbalance, it's a sustainable business. So a responsible business is a sustainable business, and business, human rights in the conduct of business transactions is non-negotiable. So thank you very much. I hope that we have learned one or two things from this, and yeah, all the very best. Thank you once again for having me here.
All right, thank you very much, Mrs. Roots, for your very, very wonderful and elaborate discourse, highlighting areas around labor laws as it concerns and relates to business and human rights, also with the rules of technologies and what companies should begin to take into notice. So we sincerely do appreciate your shared discourse in this session. We still have one more mentor who would like to still hear from. Ms. Ibuka, thank you so much for staying all through while we listen to our previous two mentors. We hope that in listening to your discourse, we also get to hear you share some very, very fair perspective to the subject matter for today, and we can get a well-rounded finality to it in that sense, considering that we have moved through two other mentors. So, Mr. Ebuka, I would like to give you the floor also for another 20 minutes to help us run through it or run through your discourse.
All right. Thank you so much. Hello, everyone. My name is Ebuka. I know I've been introduced earlier. First of all, I want to commend the earlier speakers, Mr. Joseph Obo and Ms. Ruth Soran Nadim. Your camera, sorry, your audio was quite audible. Everything was perfect, and I just hope my audio is as good as that of the earlier speakers. Hope everyone can hear me properly. Moderator, can you hear me?
Yes, sir, we can hear you, sir.
Very well.
Very clear.
Oh, great. Thank you. I think my presentation today, I made it a little bit more elementary than what the earlier speakers had discussed about. But first of all, I want to even make it interactive. And I was just wondering, can anybody here tell me any human right whatsoever? Anybody here? I think I saw, let me just call people randomly. I don't know if you're in a noisy environment, but if you are, you can drop something on the chat box. Abasi, can you say anything? Or Adinde Ozioma Gabriela. Tell me any human right you know, anyone, right to anything you know. Ozioma, I know your heart is pounding right now, but don't worry, just anything that comes to your head. Or Abasi.
Jesus Christ, how did you know? Any human right?
Yeah, any human.
Right to freedom of speech, right to
Thank you.
freedom of association.
Thank you. That's right. I know you'll be wondering, okay, well, any other person, Abasi? Is Abasi still here? I don't know if that's your first name or your last name. If you are not here, Ososa Joshua, please, can you just any human right you know? I want to make sure that the people here did not just dump their phone and left to cook, because it's almost time for dinner. Okay, I think they are struggling with speaking to the large population here. All right.
Right to dignity of human person.
Oh, good. Thank you so much. Any other one you know? Sorry, who is speaking? Can you please tell me your name?
Right to privacy.
Emmanuel. All right. Who said right to privacy?
Imabasi.
Okay. All right. Thank you so much. First thing I want to tell you, or tell everybody on the call today, is that there are concepts of human rights. And one is that it is universal and it is inalienable. It is inalienable. And okay, somebody said right to fair trial. Okay, thank you. Joshua does not, I think he's in a noisy environment or something, or he has stage fright, but thank you for responding. So it is universal and it is inalienable. For instance, If there is a right to life in Nigeria, there's also a right to life in Ghana. There's a right to life in Congo. Although there are margins of appreciation, just like the International Criminal, not International Criminal Court, the European Court of Human Rights would say that there's a margin of appreciation. So the way Nigeria appreciates certain rights, it's not the way, let's say, Canada would appreciate those rights. For instance, right to free speech, and I'll come to that. As you all know, the elementary law for human rights in Nigeria is the Constitution, particularly Chapter 4. This is elementary, but I don't want to take it for granted. And it is codified from chapters, from section 33 down. So 33 says right to life, 34, right to dignity of the human person, personal liberty, and so on and so forth. I don't want to go giving you these rights one after the other. However, there are other laws that codify human rights. I'm sure you guys must have, the people on this call, you all the mentees must have done this in many areas of law. For instance, there is the Universal Declaration of Human Rights, which was done in 1948. It was adopted by the United Nations General Assembly in 1948. It is the foundation of modern human rights law. If you understand international politics well, you know what happened in 48. Between 39 and 45, you know it was a time everybody was killing everybody. And Europe was the center stage. It was the parlor, the living room for the war. Germany thought they could conquer everybody. They wanted to do like Genghis Khan, and they started showing themselves. And then it resulted into the World War II. After all the maiming, they dealt with the Jews, especially the ones in Poland. So, the world thought to sit together and promulgate this law, or rather, this declaration for ourselves. So, it is a foundation for modern human rights law. It contains civil, political, economic, and social and cultural rights. However, it is not legally binding. It is a declaration, not a treaty. But you can use it for strong persuasive authority when talking about your rights. There are other international laws here and there, like the International Covenant on Civil and Political Rights, International Covenant on Economic, Social, Cultural Rights, and all of those. However, here in Africa, which is the regional framework, we've got the African Charter on People's and Human Rights. I don't know if I'm saying it properly. And it has been codified in Nigeria. So we do the dual system where if you pass any law upstairs, when I mean upstairs, the regional body or the international framework, it does not just take direct effect in our country. There are countries where if they're member states of any international organization, you pass a law that automatically takes effect in their country. I don't know if England is like that. I can't really remember. That is the United Kingdom. But for Nigeria, whatever you pass there, we have to domesticate it here. We have to go through it and say, okay, we accept certain things. And so we passed its ratification law in Nigeria for this African Charter. And it is enforceable in Nigeria. You can look up the case of Abacha and Fawemi. I just mentioned about the Constitution of the Federal Republic. And also in practical terms, if you want to talk about human rights, this is when you start practicing. When you want to do human rights, there are laws that regulate how you go about it. Number one is the Constitution. Number two is the Fundamental Rights Enforcement Rules. So it states the rules on how you want to go about it. And then, of course, is the High Court Civil Procedure Rules of different states. Like in Abuja here, I practice in Abuja. We've got the High Court Civil Procedure Rules of last year. Last year is 2025, yes. So that's it. I don't think I should bother you or I should bore you with how you do these things, how you file it in court, but you can come through a petition. It is one area of law that if you want to protect the rights of anybody, you can almost go in any originating process, but most people just use the direct petition. Now, I want to ask a general question, just a quick one. It's a case study of what I did. You work for a hotel in Abuja or in any state in the country. You were hired in the foods and beverages industry, section. And because of the short staff within a given period, you were asked to go clean the drainage. And in cleaning this drainage, you use an acid, let's say hydrochloric acid. And while on it, of course, as a Gen Z now, we waited 22 years, 23 years, Gen Zs. You were carried away on TikTok, pressing your phone while mixing this acid to dilute it, just to clean that drainage. And the acid became corrosive and injured you. Do you think you have a right to protect under this business scenario? Because of course you're under employment. I don't know if anybody got this well. This scenario. You were working, you were hired in the foods and beverages industry or section, but you were just moved quick to go clean. And that cleaning involves you handling a corrosive chemical, hydrochloric acid. And for one way or the other, it injured you. Do you think you have any right to protect in that employment scenario? Can anybody tell me? Ozom, I know your heart is beating, but I won't call you. You've tried. So I don't know. Joy Akubwe, Abigail Ajoke Sani, and okay, Akande, please. And how do you pronounce your name? Is it Akande or Akonde? Please, you can speak up, Hanif.
Yeah, hi, good evening, sir. My name is pronounced Akonde.
I thought that was much Akonde. Thank you. Please,
Yeah,
go on.
thank you so much, sir. So, I think the scenario you just made now, I think it's sort of referred to as contributory negligence. Yes. So, it's basically a scenario where the person is directly responsible. Yeah, your own personal negligence contributes to whatever harm or damage that you suffered. So in this scenario, due to the fact that the hypothetical employee was themselves watching TikTok, being directly negligent, which resulted in the harm they suffered. So I do not think that person has any right to protection that they can claim. Yeah, thank you, sir.
Thank you, thank you. Are you still an undergraduate? Are you an undergraduate?
Yes, I'm a 300 level law student currently.
What university?
Obafemi Awolowo University, sir.
All right, that's a good one. Thank you. Any other person? Any supporting opinion? Any contrary opinion? Anything? Any other person? I will call names randomly. Akubueze, I don't know if I've called you, but please. Any other opinion?
Okay, good evening, sir. My name is Ajoke.
Okay, Ajoke, yeah, I called you earlier. Please go.
Okay, so I think that the employee will be like he has a right to protection, and that the employer may incur liability for such hazard that may have been caused to the employee rather, especially because it was how do I put it now? It's a workplace hazard. Yeah, so I think he's entitled to some form of protection, as the case may be, at least maybe medical attention by his employer.
Thank you, Ajoke. Thank you so much. What school are you in?
I'm currently a bar aspirant and awaiting my results.
Oh, okay. Oh, that's nice. That's nice. All right. Any other person care to contribute? How many minutes have I spent, moderator? I just want to make sure I'm not exceeding my 20 minutes.
About 10 minutes, sir.
Pardon?
We spent about 10 minutes already, sir.
Okay, I've spent 10 minutes. Okay, that's fine. All right. So, does anybody else want to say something? I want to make this as interactive as possible. Okay, let me call someone else. Charles, please. You have two English names. Charles, please. Don't leave the call when I call you. All right. I know some people are struggling with speaking to the crowd. That's fine. All right. So the both speakers, you've done excellently well. This is a real life case. Real life case. And for some of you here in Abuja, you know the Dennis Hotel. There's a hotel called Dennis Hotel. And the case is Dennis Hotel versus Michael Richard. And I was the lawyer in this suit. And everything you said, we actually argued in this. The first speaker said it is contributory negligence. And that is correct. And the second speaker said you have a right, and that is also correct. So while this suit was ongoing, the other side argued that the litigant, who was on TikTok playing as a young boy, was contributory negligent. But then we counter-argued that he is so, first of all, you have to train him in that area of work. It is his right, and this affects business and his human rights. So you don't just pull somebody from foods and beverages and then put them in cleaning, especially if you know you are exposing them to hazardous chemicals. That was our first argument. So there's no training. Secondly, which I know I did not give you these facts, but I didn't want to make it too long and confusing. Secondly, you did not provide PPEs, that is protective gears, to them. Even if you did, how protective can it be? So imagine me handling corrosive chemical and you're just giving me hand gloves. It can pour me on my face. Hand glove will not cover my face. And this actually poured on him in his face, in his stomach, and in his private parts. And he's currently blind on one eye, the Michael Richard. Now, the argument on contributory negligence, we killed it with the argument that you are supposed to provide a supervisor at all times in your business environment. I want you to know this, to know your rights. Like Sorondati said earlier, the problem with Nigeria is that we do not have enough jobs. And so the one you have, you hold it tight like your life depends on it. But there are laws guiding these things. So both of you made good. This matter came up at the National Industrial Court in Abuja here, and we got judgment, and the gentleman was awarded 25 million naira. It's currently on appeal anyways. And we're currently at the Court of Appeal. That is one case scenario. Now, speaking of human rights, there are areas where human rights can conflict in one way or the other. So, for instance, your freedom of speech can affect other people or would be claimed to have affected the state. For instance, in the case of Yahya Sharif Aminu, he gave an opinion on religion, and then the state arrested him and sentenced him to life imprisonment. And we got the matter overturned at the High Court because it came from the Sharia court. We appealed to the High Court in Kano and obtained the judgment, but then referred us back for retrial and we refused. We went to the Court of Appeal, decided to the High Court, and we went further high. I wouldn't want to delve much into this because it does not concern business directly. It just has to do with human rights. It does not concern business stricto sensu. So I'll leave that. However, I think basically that is it for the case scenario. I also quickly want to talk about a few practices in Nigeria that are not ethical. Just like the last speaker also said, Soron Nadi, the no refund policies in our workplaces are most times wrong, especially like you see online. You would even see, especially for the Instagram vendors. Let me give you also another case that, although we haven't filed yet, but it's currently ongoing. So a client who also works as a colleague was wants to have a child, a single woman. And so she inquired from an Abuja-based hospital about the cost of IVF. I know you know what IVF is. And then they gave her a fee schedule and she made the payment, 5 million. She paid 5 million. And then she went back to the donor for the semen, and the person pulled out and said, no, I do not want to do this again. I do not want to continue with this again. And so she called back the hospital and said, can you please refund me my money because the person I'm supposed to get the semen from is no longer interested. And the hospital said, no, your money is not refundable. And now I'm asking you, do you think that without first prior notice to the would-be patient, that the hospital can retain all the monies paid to them? If not, to what extent can they refund any of the amount? I don't know. Can anybody give me just quick so that we just round up, please? Anybody, do you think that the hospital can refund the money? And if yes, to what extent? Is it 100%? How much can they keep? You know, can anybody tell me anything? Christabel Egan. Is it Egon or Egan? Christabel, you have to say something. Delegate Tangu, your name sounds very unique. Can you also say something? Delegate Tandu. Favor has left because she thinks I'll call her. Christabel. Mustafa has also left. All right.
Yes, sir. I didn't get the question.
All right. So I was asking, just let me. A lady approaches a hospital, a fertility hospital, to help with IVF. Do you know what IVF is?
Yes, sir.
All right, very well then. And she was supposed to get semen from somebody for the implantation, and the person refused to carry on with this, moved on. But before then, before the person refused to go on with the process, with the procedure, she had committed 5 million to the hospital, and the hospital says it's non-refundable. Meanwhile, prior to that time, she was not told. Do you think that she can recover back the money she deposited with the hospital? And if yes, what are the percentage you think she might recover? 100, 90, 95, and what is your reason? I hope you understand it now.
Yes, sir. So I think she may have a basis to recover her money depending on the circumstances and the agreement with the hospital. They might have to consider if there was the existence of a contract, that if she paid for the services, that there was, if she paid for the services, I believe that there must be a likelihood for a contract. The hospital is generally obligated to provide agreed services or refund if they cannot be provided. And secondly, if the service cannot proceed, the hospital or donor refuses to provide it, it should be considered as a breach of contract. And also, I think many fertility clinics have policies about cancellations or service non-provision. You should check any written receipt or agreement, see if refunds are allowed.
Very well then, very well. Thank you so much, Christabel, and that was straight on your words. It was on point. And to a great extent, I agree with you. In fact, I agree with you over 99.9%. Just to add to what you've said, yes, she has the right to collect every money that she has given to the hospital, save and except for any part that has been used for any, let's say, pre-testings, and usually before these things, they do testing, they do counseling, they do all of these things. So I actually think that she had the right to recover her monies back, everything, especially for the fact that she was not told earlier about the no refund policy. And even if she was told, it is subject to the FCCPC guidelines and the Consumer Protection Act and all of those. So I think that brings me to the end of my presentation, but this is my takeaway point. Every business generally should strive to protect human rights, because it goes on to protect you. It goes on to first give you a good reputation. It also helps to make people trust the brand. I would have wanted to go on about the three pillars of the three United Nations guiding principles on business and human rights, but earlier, the learned gentleman discussed that, so I wouldn't want to go into that. And the legal impact on businesses, if you do not protect human rights, is one, and there's a litigation risk. I believe most of you here might be Instagram vendors. Please, you do not want to bring in the wrath of litigation. You do not want to bring that out. It stresses you and it will take your money. Even if you win the case, you will pay lawyers. There are regulatory sanctions too. So many regulatory sanctions too. So you don't want to be mixed in that. And there are compliance obligations you'd have to deal with. The opportunities for business is that it brings investor confidence, like I told you earlier on, and then it gives you brand reputation. In the future, most of you here will become lawyers. And the one thing you should have at the back of your mind is that your role is that there are advisory and compliance ones that you have to do. So you have to even advise on the compliance issues even before they happen. That is part of risk assessment you have to do as a lawyer, because you have to advise your clients. You don't wait for them to enter before you help them. Then you have to, of course, the litigation and advocacy. Then, of course, policy drafting. This is also one area where you see lawyers move. But most of the questions I raised there earlier on in my slide, I wouldn't be asking them because I already did mid seminar. Some of them even do not particularly affect business, so I'll leave it at that. Thank you, everyone, and this was really insightful. Thank you to the mentors who also presented, Mr. Joseph Obo and Ms. Ruth Soronadi. Thank you, Jim.
All right, thank you so much, Mr. Ebuka, for running us through your discourse, bringing out real case scenarios, highlighting issues, and getting our mentees to also participate in the discourse. We really, really do appreciate. So yes, our mentors have gotten the opportunity to speak, share their thoughts, procedures around the business and human rights angle to work, our rules, the rules of companies, the rules of individuals, legal remedies they can take. What are the pillars of the UNDP human rights commission, like the laws themselves? What are the pillars upon which they stand? And our mentors have just done due justice in running us through all of that, and we sincerely do appreciate. For the mentees, I would really encourage us to follow up with this class. The class is being streamed, right? So you can follow up after this session. But before we go for today, like we usually do, we'll be taking questions. I'm sure that there has been a lot in terms of the discussions that we've had. Our mentors have shared their thoughts and perspectives. Are there questions we would like to ask? Then in the next few minutes, I encourage us to ask questions to just better overall get more out of the mentors in maybe aspects or areas that they may not have said a thing or two, but may want to highlight on using your questions. So please, do we have questions from the mentees? If you have a question, you can kindly indicate by raise of hand, or you can send your question into the chat box. I encourage us to ask questions. Please, let's ask questions. Okay. So while we wait for questions to come, I think there's something I want for our mentors to do for us before, we draw a curtain on the session for today. I want to ask if it's possible to get some final notes or some final thoughts from the mentors, and then maybe any advice they would like our mentees to have, overall in relation to business and human rights. Let me start with Mr. Joseph right from the top, and then we'll go through our mentors. If there are any questions, I will ask them. If there are none, then we'll call it a close on class. So, Mr. Joseph, please, do you have any final thoughts for our mentees?
Well, I would just say that the business and human rights space, it's a virgin space in Nigeria, and I can tell you that if you dig your heels in deep enough, it's also a space that can deliver to you in terms of the economics. If you look at the corporate sustainability due diligence directive, that directive is an EU directive that is already in force within the European Union. Countries like Germany, France, let me even stay with Germany. Germany has passed a sustainable due diligence law in Germany that is binding on German businesses that do business across the African continent. What does that basically simply mean? It means that for every German business that is carrying on a certain level of, business in Nigeria, for example, let's even restrict it to Nigeria. That means that that German company in Germany has to carry out human rights due diligence on all their suppliers. They are duty bound by law. They have to carry out human rights due diligence on all their suppliers in Nigeria. So if you position yourself as that expert, somebody that has a local knowledge, somebody who is within, this particular terrain, and you put yourself out there as somebody who understands business and human rights, maybe you run programs, you can do a lot of things just to prove that point. You can create a business model, out of this interaction and see how you can start pitching those foreign companies. They may necessarily not need to come to Nigeria to do a whole lot of stuff. You are the eyes that they have here, the ears that they have here. You are their compliance agent here on the African continent. And if it's something that you are, open to, if it's something that sounds great to you, it's something that you can really build a career out of, alongside other things I may want to do. But if you want to see it as something that, oh, this is a beautiful idea, let me research more into this, please feel free. The information is all out there. Most of all these companies, they all have social media platforms on LinkedIn, for example. So I just felt I should put that out there because we need a whole lot more persons, coming into this space beyond policy. Beyond policy, you can create a business model out of business and human rights, providing services for multinational companies that have their footprints on the African continent. That could just be a good starting point. Yeah, thanks.
All right, thank you so much, Mr. Joseph. Mrs. Ruth, do you also have any final thoughts for our mentees?
Okay, thank you very much. It's really been a very interesting session. Apart from speaking, getting to listen to Mr. Joseph and Mr. JIIPCC was quite impactful. So I'll just say this because this is a mentorship program and I think we have a lot of budding lawyers here. I would say that as long as people are in a space, human rights would definitely come in. You don't even need just one person is enough. And there are different aspects of law, but I'll encourage just be that lawyer that knows a little bit about everything. It could help you. And then there is no aspect of law that you're going to be involved in. Whether you're working in a law firm, whether you're going to open your private practice, or even if you're going to go outside law, even if you're going to get into policy, do well to know what applies there. That's what makes it. We use the term business, but I will just use business. I will just define business as a generic term. Whatever it is that you're doing is business. Whatever it is that you will do after your law degree, it's your business. Know the rights that apply there. That's why you are a lawyer. And that's why I believe this whole mentorship program package is ongoing. Maximize it. All the very best to you all, and well done to the JIIPCC team. Kudos. This is something remarkable and very impactful that you're doing here. Thank you.
All right, thank you so much, Mrs. Roots, for your shared thoughts. So before we head over to Mr. Ebuka for his final thoughts, Ugumirabel Kususochukwu is asking, good evening, everyone. How can businesses balance profit motives with the responsibility to respect and promote human rights, particularly in contexts where local laws may not adequately protect workers' rights? So I don't know exactly which of our mentors I should direct this to. So I don't know. I will leave it open. Any of our mentors that may have something they would like to share in regards to this, please, I leave the floor open to us to help address Mirabel's question.
Okay, while I believe other mentors will still have one or two things to say, but I think the last part on where local laws may not adequately protect workers' rights, I am finding it difficult to believe that. I don't think there is any place in Nigeria that is not covered by our laws. So, but I understand the part of balancing profit motives. But apart from the universal obligation to fairness and dignity, all our laws protect it. The local laws adequately protect workers' rights. Okay, let me not say adequately, reasonably protect workers' rights. Like I was saying earlier, most times is either the ignorance of the employers or the ignorance of the employees. But then I really think in doing what is fair, our laws as it is now, the NDP, that's the Data Protection Act, the GAID, the Copyright Act, there are so many Sale of Goods Act, the Constitution itself. I think it's, yes, there could be some nuances that may still need to be added, but even the law as it is balances this. It doesn't say that the employer shouldn't make profits, but every worker has the right to dignity. But then it's now left on the worker to know that right in case that the employee is not aware of what the law has provided for him or her. I think the law gives room, especially, this Data Protection Act, it gives room for complaints or grievances. So I'm trying to you can make your profits without having to trample on someone or treat someone unfairly without dignity or what have you. But I just wanted to just highlight that there is no as long as Nigeria is concerned, the laws reasonably protect human rights.
All right, thank you very much, Mrs. Roots, for you helping us run through that question. I don't know if any other mentor may have anything they would like to say in relation to that.
Just okay, go on.
Okay, please go ahead, Mr. Ebuka.
Yeah, I just quickly want to make a point. Yeah, So, in response to the question from Mirabel Kosisachukwu, so this is it here. It's always easier or cheaper to protect rights than actually to pay the penalties thereof. So, for instance, let's say, for instance, it says pay under the Labor Act. It says if a staff is coming from any place more than 10 to 20 kilometers, I can't remember the distance, then you should pay them an additional amount for getting to work. Transport allowance, that's the name. Transport allowance. So you might look at it and say, nah, if I pay these guys, let's say for instance, 20,000 naira every month as transport allowance, in a year, 20 times 12 is how much? That's over 240. I don't know if my math is correct. You might think, nah, that's too much on me. Times 10 people, that's over 2.4 million. No, I can't pay this. And then you think, okay, you don't want to do that. And the person goes to court. You'll be surprised the court might award up to 5 million against your organization. So which is better? This is not to mention the cost of litigation and the stress it has put on you. So on the face of it, it will look like, okay, I want to make gain. Let me make my money. These boys, they do not know the rights. There is a difference between profiting and profiteering, where you make excessive money by exploiting certain crises. Crisis can be war, it can be anything. It can even be ignorance of the people that you've employed. Trust me, it's always, always, always cheaper to do the right thing. It's always cheaper. I've seen it throughout close to a decade of experience in litigation. It's always cheaper to do the right thing. And then I want to also agree with Soron Nadi. You see, our laws are very extensive. The only places where we have small loopholes here and there is aviation. Then things about nuclear physics, nuclear materials, nuclear particles, and all of those, and space law. Those are, and then issues concerning medical law like IVF, the rights of surrogates, those kind of things. That when you ask a woman to, in the course of like a business, to have a baby for you, or you and your partner, you pay somebody else to carry the child, except for Lagos that are the trailblazers. Other states are still coming from behind in this context. You see, those are the small areas where we do not have, where our laws are silent on it, especially when it concerns the rights of other parties and it concerns business. But aside that, it is very, very extensive. Now, the thing with Nigeria is that most people do not go to court. And sometimes I will not blame them. And also I will still blame them. We do not go to court because we do not trust the institutions and it takes too much time. There are too many cases in the court. People say Brazil and India have more cases, but to me, I think we might have more cases than even Brazil. Save maybe for the population, we have so many cases that nobody is attending to. You understand? So what I'm saying is this: always elect to do the right thing, or else the wrong thing will cost you more. Thank you.
All right, thank you so much, Mr. Ebuka. I think we'll just get back to you on maybe any final thoughts you would like to share with us before we end this session.
Well, my final opinion is this, and this is, I don't want most of you coming into the system to make the kind of mistake I did. So there are so many areas of law to practice. Do not constrain or streamline yourself, and I'm most especially advising the women here, the girls. Sometimes, let me tell you, the ladies do the best in law school. Most times, especially from my set. You people perform the best. But for some reason, you abandon law. You abandon everything. You even abandon the areas of human rights, even business altogether. And sometimes it's not even because of family. I understand that that can also be a strong reason, but there are people who it's not even the reason. I understand the industry is male-dominated and it can be very patriarchal. But this is the good news. You see, you do not all have to go into litigation. You do not all have to go into this. There are so many areas of law that would give you even more money than you think litigation. In fact, if I were to say litigation is the least profitable area of law. It is the least profitable area of law. The best part that will give you money in litigation, especially as Nigeria is concerned, is usually election petition. And that is usually left for the big boys. Other than that, you do maritime here and there, you do oil and gas, 1 or 2 places, environmental law, yeah, there and there. But it is only when you get very high profile briefs. You understand? I'm not saying it is not profitable. Trust me, there are people who make in dollars here. But there are also certain areas that in less than 180 days it is done. For instance, capital markets. The intersection between law and tech. I have a background. I just finished my BS in computer science, and I'm also a lawyer. I can tell you now that there are so many areas, and just like Sorona said earlier on, the data protection is a strong area of law. In fact, for you to be a compliance officer for under the, I'm trying to remember, I did not need the commission that handles this. I think your firm has to, I think, a 2 million naira deposit alone. That is how to tell you how advanced this place is. There is capital market, there is other areas. I wouldn't want to take much of you guys' time in this area, but generally I will tell you, keep doing what you are doing best, keep pushing, and I hope everybody comes out well and get the best out of life. Thank you.
All right, thank you so much, Mr. Ibuka. Thank you so much, Mrs. Roots, and thank you also. Okay, Edits question as a final question for today. Please go ahead and ask your question.
Okay, good evening, everyone. I just want to confirm if you can hear me.
Yes,
we
please.
can hear you.
Okay, thank you very much. So, I would like to say thank you, first of all, to all the mentors. There are 3 sessions that are very insightful. Then moving on to my question. I have a question in particular to Mr. Joseph. That was the first speaker. I listened very closely throughout his presentation, and what piqued my interest the most was the Dyson case where settlements were given. I have a particular, would I say, strong contention about settlements, especially in human rights case, and especially considering the nature of the organizations. One that is very, would I say, powerful. There is a significant power imbalance between the organization itself and then the workers. So moving into settlements now, given that power imbalance between that corporation and then between the victims, how can we as lawyers or budding lawyers or just the law in general, how can we ensure that in these settlement cases or in these human rights cases, the settlements are fair, that they are adequate, and they are not exploitative? Because I can't really remember the case I was reading, and or just in many scenarios, we see cases where the victims are mostly forced to agree to settlements that are not really effective or adequate enough for the circumstance that they pass through, or something like that, because of that power imbalance. So how can the law ensure that, okay, if we are going into settlements, these settlements are fair, that they are adequate, and they are not exploitative of the victims?
All right. Thank you very much. Sorry, I had a phone freeze, but I think I still got your question. What I would firstly say is that even the law itself encourages alternative means of resolving disputes. Whether the issue of sufficiency and all of that, if you have a good lawyer that already knows that, because every lawyer, when you go into a case, my expectation of myself is that, on a civil matter of this nature, you should have like a lower limit, you should have an upper limit. You should already know, okay, what am I expecting from this particular matter? what do I want to get on behalf of my client? So if you already have that sorted out and you are a good student of negotiation, when a company now tells you, we don't want to go through the harrowing experience of the court system. And don't forget, like in the Dyson case, for example, personally, what I feel is that this is UK law. Like they would unravel that entire company, like everything that company has existed for will be before the courts. No company that knows that they have an opportunity to be able to settle out of court would now want to subject themselves, to the rigors of, the judicial system. You would be shocked that that case, if at all it landed in court, it may have created other patterns, like maybe other cases could arise from just that case based on information that may be available to the public with respect to the scrutiny of that company within the judicial system. So companies that are smart with smart lawyers, of course, they would want to negotiate. And there's really no law, especially in this kind of, there's no law that would prevent them from negotiating. And don't forget that when you take someone to court and you now say, okay, you want, even sometimes the judges will even ask you, can you settle? They would want to see how both parties can settle those matters. If it was something maybe of a criminal nature, for example, to prove certain things, proving certain things beyond reasonable doubt, all of those intricacies, a case can go either way at the end of the day. So some of these litigants too might want to see, okay, how can we cash out? Okay, if we get 100 million, we can split amongst everybody who has been impacted by the actions of this particular company. Let's see how we can get what we can get instead of spending 2-3 years to do that. The cost of paying a law firm, all of those factors are considered by, people who would intend to engage lawyers. And at the end of the day, all they still need is money. If you say a company is guilty, for example, like it doesn't really put funds in the pocket of, people who have suffered, the wrongs committed by the company. So when individuals or when communities realize that, oh, if we have these $1 billion or 200 million US dollars, and they have a law firm that has warehoused, assisted them to negotiate that whole funds, and everybody gets something for their pain, people would most likely just not want to go through the whole rigors of going to court, because at the end of the day, it's still money. It still boils down to people looking for how to get some level of settlement that they determine by themselves to be enough to suit the pains that they may have suffered as a result of the actions of these companies. So personally, as someone who is a lawyer and also as someone who also is into business, I feel that settlements may not be the best way for every kind of infraction. But for certain kinds of infractions, I would even advise companies to go the route of settlement. But like I said during the lecture, the idea is for companies to see this risk before they become detrimental to people who are being impacted by the actions of these companies. Nip those risks in the bud before the risk now becomes an issue. Even this Dyson case, for example, if you look at their reputation, somehow we are talking about Dyson because of this issue. Somehow at the back of our minds, we are thinking this company must have done something wrong. It's also not too good for the reputation of the company, but somehow too, they are also seeing how they can cut their own losses. We don't want to go through the harrowing experience of litigation. Let us settle this matter. Let everybody be happy. More like a win-win, like no losers, even if they are losers anyways. But at the end of the day, everybody goes home with something. So that might just be like a pragmatic way to resolve some of these disputes without having to go through the entire court system.
Thank you very much, sir.
Yeah, thanks a lot. Yeah, cheers.
Thank you very much, Udwak, and thank you also, Mr. Joseph. So just before we go, before we call it a close to class, we would like to quickly take pictures. So please, for everyone who can, would like to ask us to quickly turn on our videos. Let's quickly take pictures, and yeah, while we call it a night. So please, let's kindly turn on our videos as quick as possible. Let's do that in 1 minute while we wrap up for class. Or we wrap up with class rather. Okay, thank you, Grace. Thank you, Joshua. I can see we are turning on our videos. Thank you, everyone. Let's quickly do that. Thank you, thank you, thank you. All right. Okay, still taking pictures. Yes, so yeah, we are done with the pictures. Can we hear me? Can we hear me? We are done with pictures. Thank you, everyone, for turning on your video. So, for the mentees, this is the first of the classes we'll be having for week 6. We still have other sessions that we've scheduled for tomorrow down into the weekend. So please, I would like to kindly encourage all of us to try as much as possible to make ourselves available for the sessions. We do promise that the sessions that have been designed particularly to get the best for you in terms of what you would need to arm yourself with after you're done with the program. So please try as much as possible to make yourself available for the sessions. So our mentors that were around in today's class, running us through an area of law that not so many people talk about, human business and human rights. Please, we would like to say a big thank you for the mentees. Don't forget to share what you have learned in today's session. Tag your mentors. I'll be sharing their flyers. Okay, just before we go, I would like to ask the mentors if we have your permission to share your presentation with the mentees so that they can look through it for themselves. So, yeah, with that, please do have a wonderful evening, everyone. Enjoy the rest of your evening and see you all on the other side. Bye bye.
Thank you, sir. Bye bye, sir.
Thank you.
Bye,
All
everyone.
right. Yes, bye bye.
you.